The state of Alabama has asked the U.S. Supreme Court to intervene in the ongoing Voting Rights Act dispute over the state's congressional map.
Yeah, that new appeal follows a federal three-judge panel's opinion last week rejecting the map and its Monday order refusing to pause court-ordered plans to redraw the map. Following a Supreme Court decision in June, the panel directed Alabama to create a second congressional district with a majority or near a majority black voting age population. But the map approved by the legislature in July doesn't do that. And state lawyers say it isn't necessary. News 19 chief investigative reporter Brian Lawson joins us now in the studio. And Brian, the state has now turned to the U.S. Supreme Court. So what happens next?
Right. So the state filed an emergency petition for stay, as you said. The three-judge panel said Monday it was highly unusual for a party that lost before the Supreme Court to go back and expect to win using the same argument, but that's where it stands. Justice Clarence Thomas, who sided with Alabama in the Supreme Court's June ruling, received the state's petition and could have rejected it without comment, but it's still alive. He gave the plaintiffs who challenged Alabama's map a week to respond. Now, the Supreme Court agreed with the three-judge panel in June that Alabama's black population is large enough and geographically compact enough to justify a second district that creates an opportunity for black voters to elect a Congress member of their choice. Alabama has opposed that push. Governor Kay Ivey was asked about that position today during a visit to Huntsville.
Well, as I've said many times before, the legislature knows our state better than all the special interest groups might. And but it is what it is, and they appointed a special master, and we'll have to ride it out and see what comes out, but I believe they'll get the job done.
Now, Alabama argued in its Monday court filing, quote, "The balance of harms supports a stay so that millions of Alabama voters are not soon districted into that court-ordered racial gerrymander. Race-based redistricting at the expense of traditional principles bears an uncomfortable resemblance to political apartheid," they said. In arguing against the stay Friday, the plaintiffs said, quote, "Thousands of individuals across the state of Alabama suffered this irreparable injury when required to participate in the 2022 congressional elections under a redistricting plan that violated Section 2 of the Voting Rights Act. A stay of this court's decision would countenance the very same irreparable injury for the 24 elections, leaving no opportunity for relief until 2026. Now, according to the U.S. Supreme Court rules, it would take 5 justices to grant a stay, but only 4 justices to grant a cert petition. Basically, that would be them agreeing to review the case. The three-judge panel has said the map needs to be ready around the beginning of October for the March primary election. Further delays would likely mean the recently drawn map would be used. Christine?